Judge, if you are a believer in the doctrine of stare decisis, then just explain to me what happened in the following cases. In civil case number 1067 of 1999, which you recall, the case of Kipiator, Nicholas Biwott, and Clays Limited, Little Brown Company, and others, you recall this was a case of defamation, a claim for damages involving Dr. Ian West and others. And in this case, you had and rendered a decision. You were judge of the High Court at the time. I want to understand why, against non-decisions then, the case of George Oraro and Barack Mbaja, which arose from the same publication, an award of 1.5 million shillings was made. In the case of Abraham Kipsang Kiptanui, who was a controller of State House then, and Francis Maniki, an award of 3.5 million was made for defamation. And then a decision involving a judge, who then became Chief Justice, John Evan Gisheru and Andrew Morton, an award of 2.25 million was made by Justice Alwach. You proceeded, whilst aware of these decisions, of course they were persuasive because you were a High Court judge, to make two different awards. One, an award of 10 million shillings against Kenyan defendants, and an award of 15 million shillings exemplary damages against Clays Limited, the publishing company. Now, what I want to understand, Judge, and what baffles me, is that later, in other related, let me just cite for you another case. In another related case in 1998, when you are sitting in the Court of Appeal, an appeal by Standard Limited against Kalamkla Limited, in a defamation suit, KTN, you awarded or upheld an award of 3 million. That was in 2006. Just you are still judge, but around the same time. The only distinguishing factor, or in the facts, was that the Honorable Biwott that time was the Minister for Trade and Industry. Judge Gisheru was a judge of the High Court. George Oraro Senior Counsel was a senior advocate in the country. And you were made aware of all these decisions. Please explain, against the backdrop of your own assertion this morning to this panel, that you are a believer in the doctrine of stare decisis. Was this an isolated judicial moment? What happened?
Yeah, thank you. Let me try and explain the Biwott case and why I feel that it has nothing to do with stare decisis. Because in the Biwott case, we were assessing the quantum of damages, and the quantum of damages is an element completely discretionary to the judge. The principles on which the case was founded, liability was entered, it's a 37-page judgment that you will see is extremely well-reasoned, and nobody on appeal has ever challenged the rationale of that case. The only challenge is about the quantum. Now, let me explain about the quantum. In that case, there were 4 defendants. 2 of them, as you pointed out, foreigners based in UK, where the book was published, where the profits were made. And the other 2 were local booksellers. The local booksellers entered into a consent judgment. I did not award anything. They entered into a consent judgment with the plaintiff at that time, whereby they agreed to pay 10 million each. When I was awarding the damages, the actual claim, as you will see from the proceedings of the judgment, was 75 million shillings. And I reckoned that if an out-of-court settlement was worth 10 million shillings, which they'd agreed to pay, then a settlement following a trial in which all the allegations were established, an award of 15 million, which is 5 million more after trial, was not an inappropriate sum. Secondly, and more importantly, I took into account some factors in coming to that award, 15 million. The factors were that in this case, the plaintiff was called a murderer. Extremely important to call somebody a murderer several times in your book. Secondly, the defamatory material was published in a hardcover book. It wasn't in a newspaper that is read one day and destroyed the other day. And this hardcover book, published in the United Kingdom, was found in libraries around the world. In fact, the exhibit presented to the court was from a bookshop in Singapore. And the third thing there was that there was evidence before the court that the publishers and the authors were earning profits of this book in British pounds, in sterling pounds. It had no relationship to the shilling figure here. And the profits earned in hard currency, in sterling pounds, amounted to quite a lot of money. And so I reckoned that 15 million shillings, or 5 million more after trial, was not worth more than 200,000 pounds or so, and a fair award to make in the circumstances of that case. That is what dictated my discretion. Quantum is a matter of discretion.
Judge, all these cases that I have referred to arose from the same hard-covered version. And this is what you said, and this is what worries me. I'm at page 11, I must say that I've been particularly troubled by the inordinately low awards made by the High Court in libel cases. This is especially so with the latest case of the Honorable Justice Gishiro. That award is manifestly inordinately low. I believe I have found the reason for this low award. Then you explained at page 12, Judge Alwaj stated the prayer for damages is left with the court's discretion. That's exactly what you explained. Judge Alwaj then, of course, awarded 2.25 million, which you considered low. My concern is this, and this is comparative. I'm sure you have read comparative jurisprudence in the award of damages the world over. The highest is from Singapore. Should Kenyans be worried about Honorable Al-Nashir Visram as Chief Justice in view of the new provisions of Articles 35, 34, and 33, and the dispensation towards free speech? What kind of Chief Justice would you be, having in mind the possibility that you are one then who would discourage or who would be seen as constricting free speech?
Well, Kenyans need not be worried at all, because the restriction is not on free speech, the restriction is on irresponsible speech. Because the whole purpose of the judgment was to tell the world that these people were wrong, were irresponsible, were malicious, didn't even defend themselves. And my notion of free speech is not to give liberties to abuse and to lie. That to me is not free speech. So that is my position on, and I can assure Kenyans that Kenyans have nothing to worry about. That is not the only judgment I wrote in the judiciary. I've written 2,000 plus judgments over a period of 17 years. And I hope that Kenyans will not be so scared about one judgment as to what kind of a Chief Justice I will make if I made one quantum award that is disproportionate in the minds of some people.